All right, everybody, it is 1 minute after. My name is Sean Casemore, and I want to welcome you to our inaugural Access the Experts event. This is the first in a five-part series. So we really appreciate you joining us here today, and hopefully you'll continue to come back and enjoy these series. There's going to be lots to come, so watch our newsletter for more information on our Access the Experts event. I'd also be remiss if I didn't mention that at NGen, understanding what's happening in the environment here, we've actually created quite a few events that you can attend at no charge. They're all complimentary in our goal to really help everybody here to move their manufacturing businesses forward in these struggling and challenging times. So this coming Thursday, we have another event. That event is in our What's Next Thought Leadership series, and it's Surviving the Second Wave. It'll be Thursday at 11 a.m. You'll see registration information in our newsletter, which goes out tomorrow. I really hope you'll join us there as well. Now, that said, let me get started with a couple things for today's event. Today, what we're going to be doing is if you have a question, okay, please use the chat box. You'll see it along the bottom of your screen, okay, and you can simply type your question there. I'm going to monitor those questions, and I will ask them when we get to the question and answer period. If you accidentally use the Q&A box, don't worry, we'll manage that as well. We've got it covered. But if you could try to use the chat box, we'll keep it to one area. I will monitor and ask those questions when we get to the Q&A period. So all that said, let me get started here with a quick introduction. Intellectual property is really a valuable asset for any organization. It sets you apart from your competition, as many of you know. Just what is intellectual property, and are you giving your IP the attention it deserves? That's really the question. Well, today you're going to learn about identifying and protecting your IP. Peter Milne, a partner at Gowling, WLG Canada, is an intellectual property lawyer, a professional engineer with a degree in materials, a patent agent, and a trademark agent as well. No small feats by any shape of the imagination. Rhonda, she is the senior IP manager at NGen Canada and has over 15 years of in-house intellectual property management experience with global manufacturing organizations. Rhonda is part of our NGen group here, and she is somebody that I've come to really recognize as an expert in this area as well. So with all that said, again, I want to welcome everybody to today's session. If you have questions, please put them in the chat box and I will ask them at the appropriate time. And with that said, Rhonda, let me turn it over to you.
Hi, great. Good afternoon, everybody. Just welcome to our first Access the Expert IP series. So the goal of our series is really to raise the awareness of IP and hopefully provide some really good practical knowledge that you can apply to your organization. Intellectual property is all around you. It impacts so many aspects of your business. It affects the development of your new products. It affects procurement. It can affect the way you work with other organizations. And it can be everything from your data, your know-how, your products, your processes, your business information, your brand. It's a huge asset, and it can really provide a competitive advantage and distinguish you over others. But if it's someone else's, it can also prevent you from doing something that you'd like to do. So the first in our series is really going to be a bit of a high-level introduction to the way IP can be protected and what you can do at your organization to prevent the inadvertent loss of IP before you've actually had a chance to properly review it and make a decision on what you would like to do with it and how you might want to protect it. So as Sean said during the presentation, I encourage you to submit any questions you have into that chat box because we will be spending some time at the end of the presentation to answer as many of your questions as possible because this is Access the Expert. So we're going to start first off with a few polls just to get a sense of the background IP knowledge of everybody who's sort of attending this seminar today. So let's move to poll number 1. So does your company actively manage their IP? Perhaps you can take a minute to answer this. And we'll post results once they're in. Right. So pretty mixed across all the answers. So 24% of you say yes 100% of the time. Some of you say most of the time, which is great. Some of the time, not really or rarely, never and don't know. So real mix across the way. Now we've got a second polling question for you. Does your company have a dedicated intellectual property resource? Frank, have you? Oh, perfect. Hmm. Hopefully, we'll see those results soon. There we go. So 19% have a full-time person or department. 16% have someone who takes that on as their part-time role. Some external contract people, no. Wow, that's almost 50% that know, and some that don't know. So that's also very interesting information. Thank you all for your responses. Now I'd like to pass this over to my colleague Peter, who's going to talk a little bit more about formal protection of IP.
Hi, all. Intellectual property is generated throughout organizations. Some of it is high value, some of it's low value, some of it's easy to protect, some of it is more challenging to protect. There are formal ways to protect intellectual property, and that would be sort of patents, trademarks, copyright. And there are also informal ways of protecting intellectual property. And examples of that would be, for example, best practices within an organization, having processes in place to protect and review IP, and training, excuse me, and training to ensure that there's awareness of intellectual property. 30 minutes is not a very long time to talk about a subject as broad as intellectual property, and certainly not enough to give you a comprehensive guide to all things intellectual property. But we will basically be spending some time focused on key things, which hopefully will trigger you to take a look at the way that intellectual property is managed within your organization. So we're going to start with the high level definition of the more formal ways of protecting intellectual property. And the first one, and probably the one that's the most powerful, is patents. And the reason I say probably the most powerful is that patents actually go beyond stopping people from copying directly what you're doing. A well-drafted patent will protect sort of the underlying inventive concept and put you in a position where you can stop people from using the underlying inventive concept, albeit not in exactly the same way as it was described in the patent. A precautionary note: patents are published 18 months after filing. And that means that anyone can determine what your technology is and what you're seeking to protect. So if you have technology which is not reverse engineerable, you might want to ask yourself whether you want to take the risk of making that technology become available by putting it in a patent application, which is subsequently published and anybody can get access to it. So if you're in a situation where maybe manufacturing facility and you can control your trade secret and prevent people from getting to it, that might be the best course of action under those circumstances. Um, you know, by way of example, there is a famous soft drink brand which has a formula that nobody other than the manufacturer knows. If they had patented that back in the early 1900s, the patent would have been expired decades, if not a century ago. So keep that in mind when you're trying to make a decision with respect to the manner in which you're going to protect your invention.
Yeah, Peter, I'd just like to add one example I've seen. So one thing also to be careful about, in addition to what Peter sort of said, is since patents are first to file, sometimes it can be really important to make sure you move quickly if you are actually going to go forward with a patent, especially if you're sort of working in a hot area. I mean, if you're working to solve a problem in your area that's, to support your customers, there's a good chance one of your competitors might be working to solve that same problem. Um, because patents don't publish for 18 months, you have no idea what your competitors might have filed. And in my experience, I've actually seen situations where two patents from two different competitors solving the same problem in pretty much almost the same way have been filed within less than a month of each other. So it's just something to be cognizant of too, is if you do make that decision, you don't want to wait too long. Peter?
We'll take the next slide, please. Trademarks. Trademarks generally are something that links a product to its source and protects the reputation and goodwill of the owner. Trademarks is, I'm not going to spend a lot of time talking about trademarks because my sense is that this particular presentation is more manufacturing directed than marketing and business development protected. Trademarks typically would be words, logos, designs, which a certain entity would own, and that the use of that is in effect sort of a guarantee of quality to the purchaser of the goods. The trademarks don't have to be registered, but registering a trademark is actually worthwhile. One of the reasons it's worthwhile is that you get Canada-wide protection, whereas if you have an unregistered trademark, that would typically only give you protection in an area in which you can prove reputation, and enforcement is easier with a registered trademark. And just the process of applying for the trademark registration means that the case is going to become, or not become, but go before a trademark examiner, and the trademark examiner will at least search the trademarks register, and you'll know that if you passed through the trademarks process, that your mark is unlikely to be found confusing with at least a registered mark. It wouldn't really help you with respect to whether your mark's confusing with an unregistered mark. Next, please. Okay, industrial designs. Industrial design protection protects the appearance of an article. It doesn't extend to the functionality of the article in the way that a patent would. Typical examples of industrial designs, container shapes is one that is quite popular. Different brands of spirits will have, every one of them will have their own particular bottle shape. Same with soft drink manufacturers. The old glass Coca-Cola bottle and the Pepsi-Cola bottle would be examples. And then there are other things which might not come to mind as readily. The shape of confectionery is one that seems to be enjoying a pretty high uptick as far as the number of design applications being filed. Clothing, shoes, speakers, earbuds, and even the shape of an Oreo thin is protected by industrial design registration. Industrial design registration is relatively easy to obtain and relatively inexpensive and relatively quick. While not as powerful as a patent and stopping people from, copying your inventions, if you will, they're good if in situations where you're facing direct knockoffs, which might be the case when you're dealing with counterfeit goods. And another benefit or thing that you could do with a industrial design, there's a section of the trademarks regime which they're called distinguishing guises. It's basically products and their packaging, and you can ultimately protect the shape of your packaging. An example of that would be, say, the Coca-Cola bottle. The challenge, though, in doing that is that you have to be able to prove that you have a reputation, that in other words, that the shape is well recognized by the consumer as far as being indicative of a particular manufacturer. And what you can do with an industrial design is protect the shape for 10 years under industrial design protection, and then you basically, in that time you can market your product and will develop the reputation. And ordinarily, if an industrial design expires, people are free to use that design, but not if you then roll your industrial design protection into a distinguishing guise. And then next, oh, well done, thank you. Copyright basically extends to literary and artistic works. It's really a tool to prevent people from copying. Uh, Copyright protects the expression and not the underlying idea. So, if, you read a story and you paraphrase it and reproduce it using different words without copying any passages from the original text, you're probably not in a situation where you're infringing copyright. In a manufacturing industrial complex, examples of things to which copyright might extend would be brochures, company websites, like the artwork on the websites, computer programs, plans, blueprints, drawings, photographs, models. And you don't have to register copyright, but you can. It's relatively fast and inexpensive to do it. The benefit of registering is that there is an assumption that you then do own the copyright. So you don't have to, if you want to take an action in copyright infringement, you don't have to first prove that it's your copyright. But you can always, there's no deadline for when you can seek copyright protection. So you can always wait until you're in a situation where you want to enforce your copyright and then register it at that time.
Thanks, Peter. That's some really good advice. I've seen in my career, I witnessed, entire websites or portions of websites completely lifted by organizations, primarily, a lot of foreign organizations, to either sell very similar goods or make customers believe that they are dealing with the originating organization when it comes to those goods. And I think this is where, if you had something formally registered, a trademark or copyright, you might have a lot more ability to sort of shut some of that stuff down a little easier, I imagine, with a stronger worded cease and desist or something along those lines. It might carry a bit more weight.
You have something to threaten them with,
Exactly.
Which otherwise you're just upset that somebody's copying your stuff.
Right. So next, Peter.
So we've now covered the sort of, the formal ways of protecting intellectual property. From a manufacturing and industrial perspective, one needs to make sure that you avoid things happening that hamper or lose your intellectual property rights. And intellectual property can leave an organization in many ways. Sale or promotion of your product. You put your stuff out there, people can see what it is and how it works. Employees can leave, and they might have know-how with respect to not only how things are manufactured in your particular facility, but also they might know what you're currently working on. Dealing with suppliers, you have to, in some circumstances, basically, if you're having somebody manufacture something for you, they have to know how it works. Dealing with customers, disclosing information to customers, working on a new product, and you want to gauge what the market interest is in the product. So you speak to your customers, and in so doing, if you're not careful, you might just basically be giving away intellectual property rights. Cyber attack, I guess, would be a big one these days. The key thing is to make sure that you are aware of ways in which intellectual property can migrate out of your organization, and to put measures in place to avoid that happening insofar as you can. Next, please.
All right, so we're off to our next polling question. Polling question number 3. Does your company provide IP training for your employees? You can take a minute to answer that, and we can take a look at the results. Oh, and here our results are out. So, so most say you don't train your employees. You provide IP training for your employees, and then some of you say you do, but some of it's only specific departments or maybe only sometimes. It's great. That sort of leads into the next part of our discussion around employees, and I'll pass it off to Peter for talk about agreements.
Hey, one of the ways when I provided that list of manners in which intellectual property can potentially leave your organization was with employees. So the preventative measure to stop that from happening would be an employee agreement. And employee agreements are important, and they basically what they do is they will establish that the employer owns any intellectual property for that's developed by any of the employees, and that's not necessarily just inventions. That could be, if they're working in a creative capacity, copyright rights, for example. It's important that the employment agreement make it clear that upon departure, and even not only just upon departure, but in general, that the employee is aware that they are obligated to keep any information that they encounter in the process of their employment confidential. And the employment agreement should also make it clear that the employee has an obligation to assign any inventions or creations to the employer. Um, and if you want to take it a step further, you could even provide in the agreement that, the employee does hereby assign any rights in anything that they're going to develop. And furthermore, the employee grants the employer power of attorney so that the employer can sign any agreements evidencing the assignment of the invention. And the reason, that might sound a little draconian, but the reason I say that is you get situations where an employee will leave their employment and not necessarily in the um, best of circumstances. And under those circumstances, sometimes you have a disgruntled employee and they will refuse to sign anything. Or maybe your disgruntled employee, moves to another country for his or her next position. And then you're stuck because you want to file a patent application. Um, and some jurisdictions require chain of title from the person who did the inventing to the person or the entity that's trying to apply for patent protection. And if you have provisions of the nature that I just described in your employment agreement, you have an out if you can't actually get the employee to uh, to sign over to sign an assignment form. I mean, the easiest thing always is to have an assignment. It's like a page or two long, and it, provides clarity. But there are other mechanisms, that you can use if you have a proper employment agreement in place. Employment agreements should be signed when you hire somebody, because an employment agreement is basically a contract that's between the employer and the employee. And it stipulates what the obligations of the employee are under the contract and what the obligations of the employer are. If you have an employee agreement, or if you don't have one, or if you have one which is somehow deficient with respect to intellectual property matters, um, there's a challenge in trying to remedy that, because for a contract to be valid, there has to be consideration under the contract. That's a legal term that applies in contract law. But you have to, something has to be exchanged as part of the bargain that you're striking. And normally with an employment agreement, the consideration is that you're getting a job. But if you've already got the job, what's the consideration for any further agreement relating to that job? And so under those circumstances, you might want to contact an employment lawyer and discuss what the best way would be in order to give that, more robust employment terms some sense of validity or enforceability. Next, please.
Yep. So now I'm going to talk a little bit about best practices in employee training. So employees should have some kind of training around what's okay to share and what's not okay to share outside an organization. Because most employees don't want to inadvertently share confidential information outside. For example, are they sharing highly detailed design drawings, or maybe the company has a more simplified version that should be provided instead, and maybe that employee should be trained in sort of the aspects of what is okay to go out and provided with some tools to allow them to understand that. For example, also too, do employees prepare some custom presentations for external use? This is another opportunity for things to get shared outside. It might be more useful instead to have some approved standard company marketing presentations that employees are allowed to use rather than have anybody creating their own. Or, I mean, if that doesn't make sense for your business, because maybe it doesn't, maybe you have at least a review process or something in place where somebody else in the organization second eyes what they are planning on sharing, just so you can make sure that something doesn't go out that you didn't intend. Because all content that goes outside the organization should be vetted for content as well as timing of the release. Not to mention, you should also take a look to make sure that the company's trademarks and branding are being consistently used and properly marked. Your trademark becomes stronger if you consistently market and use it properly in regards to all of your outward facing branding. They should also be trained in some basic IP principles. And I mean, the R&D group probably should get extra training, but I think everybody within the organization should have at least some basic IP training around principles so that they can maybe recognize when there's a potential new IP being created. And then some kind of idea or notion as to how they could get this reviewed in the organization, what steps they should go through, maybe who they should talk to, some kind of process or policies in place just so they know what to do. Maybe there's a way to submit it. Maybe there's somebody to submit it to, or maybe they just talk to their manager. They should also have some sense of when they may need an NDA with an outside organization or a joint development agreement. Do they know when they need to reach out to senior management perhaps and say, hey, I think I really, we're headed down a path of, doing a lot of talking and maybe we need to get a joint development agreement put in place. Because public disclosure of any new inventions can really prevent you from being able to file a patent. And too much detail on information shared outside your organization can give away some proprietary information, but with little return for the organization. One thing I've seen sometimes is in company brochures, I see very detailed cross-sectional drawings of their products. And I mean, realistically, a lot of customers aren't necessarily that interested in seeing that level of detail, but it really is great for your competitors to see exactly what you're doing. Instead, almost provides something more helpful for them. So it's really good to put some thought into, do we actually need to provide this information or not, and make sure the decision's made that way. So we're on to our next polling question, which is, do you review your company's R&D and new product development projects for new IP? If you could take a minute to answer that, and we'll share the results like we have with the other ones. Maybe I'll let Peter talk about the results a little bit because it leads right into his whole section on research and development and product development.
Wow, 47% sometimes, 22% yes. I guess that's, not necessarily unexpected. But hopefully by the time we finish our presentation, some of the sometimeses will become all timeses. Research and development and product development. So challenge when you're dealing with creative people is that they like to talk about stuff. They like to bounce ideas off of each other. They like to brag about what they've come up with, or share creative solutions to problems. That's all great, except that intellectual property protection in the form of trade secrets, know-how, confidential information actually require that the information be kept secret. And when you're getting into patenting, the most jurisdictions require that you file for a patent application before the invention becomes the technical term is available to the public. And available to the public can be anything from showing it in a trade show, describing it in a brochure, selling product, you know, writing a printed publication in a trade magazine discussing a new process, for example. And so people have to be aware that, you know, that stuff has to be kept a trade secret until you make a decision that you don't want to take any formal steps to protect it, because ultimately, you know, patents are expensive and you can't patent everything. So you want to use your money wisely and look for return on investment or some strategic value to your decision to whether or not to file a patent application. So if you're in a situation where you need to have a conversation with an outside organization, best practices would be to file a provisional application. A provisional application is kind of a simple version of a patent application. It doesn't actually become a patent, but you can rely on its filing date as the filing date of any subsequently filed application if you file within a year. Provisional patent doesn't get published if you don't. Well, it will. It doesn't get published. It's available to the public if you rely on it in a subsequent application. But if you decide in the end not to go ahead with patent protection, your provisional dies a natural death and it's kept confidential and nobody can come and see it. If you can't do, you know, if you're not committed enough to go for a provisional patent, next best would be a confidentiality agreement, or what they sometimes refer to as a non-disclosure agreement. It's basically an agreement between two parties that they're going to exchange information, and both parties agree to hold that information in confidence. And the value of that is, if you disclose under a confidentiality agreement, that doesn't make what's being disclosed available to the public unless somebody breaches the agreement. But then that's sort of the weak point of any confidentiality agreement. You have to trust the people that you're signing the agreement with. And so if you're protecting if you're discussing possible ways of manufacturing or trying to gauge whether a client has, interest, so that you can decide whether you want to invest any more in developing a particular product or process, confidentiality / non-disclosure agreement is certainly one way to go. Just one more thing I wanted to say about that, or a couple of things before we get off that last slide. Sorry. And I think Rhonda already touched on this, but I'll reiterate it anyways. Engineering and research departments of a corporation are typically where intellectual property is created. And you really should have robust procedures in place to keep an eye on what's being developed and consider whether or not at certain stages in the development process it's time to start taking patent protection. Because once you put your product out into the marketplace, it's too late. So these are decisions you need to make on an ongoing basis during the development process. It's a good idea to have a robust invention disclosure form, and the format that you typically follow would be not unlike the way that a patent is set up. This is the world before my invention. This is what I've invented. These are the advantages to my invention. This is how my invention may be applied. This is how it might be practiced. And also the form should identify whoever participated in that particular product or process development. And as soon as you make a decision to go ahead with formal protection, get the assignments then, because 3 years later, when you're trying to enter, a patent application in a foreign jurisdiction and you need an assignment, the inventors might no longer be available. So it's typically a good idea to get that taken care of, as soon as possible, so you don't end up having to rely on some provisions in your employment agreement, assuming your employment agreement actually has those provisions in it. what is an invention? And because if we're going to assess, R&D, and should we go ahead and patent it, I guess probably would warrant making a couple of comments on what types of things are patentable. An invention is fundamentally a solution to a problem. And the basic criteria for patentability, the first one would be subject matter. So patents are available for compositions of matter, processes, tools, machines, software in some cases. But they wouldn't be available for artistic works or abstract theorems. You can't patent a trademark, and that's doing what I do. You often read in newspapers and stuff. People want to copyright an invention and patent a trademark and stuff. But I can appreciate that because they're all. It's not totally incorrect. You're trying to protect your intellectual property, you just haven't categorized it properly. The other thing to keep in mind, okay, so you got subject matter. Number two is novelty. It has to be new. Nobody has done that before. It has to be different than what's been done before. And the third one is inventiveness. So the difference can't be insignificant. Like, replacing a screw with a nail or a nail with a screw is unlikely to be inventive because you're replacing one common fastener with another common fastener. And so, there has to be, if there's an advantage to your solution that didn't exist in what we refer to as the prior art, that's a pretty good indication that you should take a deeper look and dig down a little deeper with respect to whether or not you should be considering protecting it. And the last thing I'm going to comment is that most patents are improvement patents. So, pioneering inventions, they occur, but usually what you've done is nudge some technology along a little bit, and as a result, what you have is better. Your process works faster, your material is 10% stronger, or it's more flexible, that sort of thing. And so, sometimes what initially appear relatively insignificant from a technological standpoint improvements actually could have huge market value. And that's, you don't gauge whether something's patentable on, how much different it is. It's really a question of, what kind of advantages are realized, and are those advantages commercially valuable? Next, please. I touched on this earlier. Once your product is in the marketplace, it's available to anybody who wants to purchase it, and you're subject to somebody taking your product and trying to reverse engineer it and copy it. Unless you have some type of formal protection in place with respect to your product, say a patent, for example, there's absolutely nothing wrong with reverse engineering. And so, you want to make sure that before you put that product in the marketplace, that you've already made the decision whether or not that's really an acceptable risk to the business that has developed that new product or process. So I could spend this entire talk on joint ownership issues and collaboration and joint development agreements. There's a lot of stuff to cover, but what I'm going to do is spend some time and just outline the topic to make sure that you're aware of its importance and that you consider taking timely steps with respect to, basically disclosing information and joint development by way of collaboration. So, if you guys are dealing with NGen, collaboration is the name of the game. That's what NGen is, largely there for. And on occasion, an engine would be one example of it. You can have different entities that might want to combine their individual skills in order to develop new product. And while that might be an effective approach from an engineering standpoint, it does present a myriad of challenges with respect to the intellectual property assets. However, if you have some upfront planning and understanding of the risks, these challenges can be well managed. So before you do any joint development, any collaboration, the entity should enter into a joint development agreement. And the agreement would basically determine how intellectual property assets are going to be dealt with. So, for example, what rights does each party to the agreement have with respect to the intellectual property of the other party? How are you going to share ownership, or are you going to share ownership of anything that's developed during the collaboration? Post collaboration, what are the respective rights of the parties with respect to anything that was developed and with respect to the intellectual property of the other party that might actually be necessary to practice what was jointly developed? What are the rights of the parties to assign their interest? Can I assign my interest to one of your competitors? Or, would I need your permission in order to be able to do so? And yeah, so, basically what I'm trying to come across and say is that, when you're going to collaborate, this stuff can all be handled. Just make sure you figure out at the outset, because otherwise people will make assumptions, and sometimes those assumptions aren't shared by all of the parties to the collaboration. And one other thing to keep in mind is, if you're going to be applying for a patent, let's say both parties want to have joint ownership, and that's another can of worms right there. You're going to be prosecuting one application through one agent, so that's easy if both parties can agree on the steps, of the process. But if it turns out that one of the parties disagrees with the other party, the agent needs to know which party has the final say with respect to instructing the agent.
Okay. And just one thing I'd like to add a little bit is, so as the senior IP manager at NGen, part of my role is to assist the project applicants and project participants in making sure that they have put together a good IP strategy where they've sort of thought a lot of these things through, and then in turn help them make sure that their collaboration agreements sort of are in line with their IP strategies. And in the end, we have had many NGen projects now that are contracted, and they've all successfully managed to put together good IP strategies and collaboration agreements that suit their project and really provide excellent collaboration, and also help the organizations protect the future commercialization activities that both parties are trying to achieve. So it's actually been really nice working with all these different groups and helping them through some of these challenges. So we have another polling question at this time. So our fifth polling question is, do you feel that you know what the difference is between a trade secret and confidential information? And again, I'll let Peter review these results with you because it'll lead right into his next section.
Yeah, I'm kind of somewhere in the sort of and no category myself. Rhonda posed that question, and it was an interesting one. It sort of made me think, because I normally think of any of this stuff sort of generally under the heading of confidential information. But if I had to define a difference between trade secret and confidential information, I think what I would say is that they both involve confidentiality. You're trying to keep information from being dispersed. But one is unlikely to share a trade secret even in confidence. I think that would be my way of putting it. So let's launch into trade secrets. I think this is our last topic, actually.
Mhm.
Trade secret protection is of no value if your product can be reverse engineered. So if you have something that isn't reverse engineerable, you're looking at patent or industrial design or some other kind of protection, but certainly not trade secret. Now, uh, product or process isn't reverse engineerable. Trade secret protection may be a good approach. Then the kinds of things that, as far as I know, were trade secrets would be, the formula for Coca-Cola and the mixture of herbs and spices in what used to be called Kentucky Fried Chicken, but I believe is KFC now. Um, the thing to bear in mind is that, and certainly when you're dealing in in manufacturing or development environment, is if you stamp every document that you have confidential, the documents are all the same. So if a court were to look at that, they go, well, everything can't be a trade secret and everything can't be confidential. And so ultimately, what you need to do is pick out the stuff that you really want to protect and protect it, in a relatively formal manner. You want to make sure that it's kept in a secure location, controlled access, um, need to know basis, maybe even have a log so anybody that accesses the information has to, sign in, and so that who has had access to your trade secrets.
Yeah. So, oh, sorry. Go on, Peter.
I think that's pretty well all I'm going to say. You had some very
Yeah.
interesting examples that you were going to share with us.
Yeah, so in terms of my experience, sort of out on the machine shop floor, the factory floor, I've seen companies restrict access to a particular area, even go to the point of having locked doors. But some of them even have just put up curtains around certain areas to make sure that, if they're ever running a plant tour for anybody, they don't walk by an area that, where you might be able to see a trade secret process happening. I've also seen locking out access to controls on particular pieces of equipment to prevent people from to prevent all the employees from being able to access sort of the background process steps. For example, the times and temperatures used in a curing or metal treating process. It could also be white labeling containers that have come in, in order to prevent people from in the facility from just being able to know what ingredients go into a particular recipe or formulation. So that's sort of more the level you might need to go to in order to really do a good job of protecting your trade secret. Because once it's out the door, you've sort of lost your trade secret, even if it left in a not so proper way. It wasn't an accidental leak. Maybe if it was even, somebody sort of took it from your organization. And but once it's out there, it's sort of out there, and you've lost that edge. So the next slide we have is sort of just a summary. We're sort of at the end of our presentation. Some of the things I just like to reiterate is, you might want to look at some of your company policies, your employee training, maybe some of the review processes you have. Take a look at the things you actually consider your trade secrets, and are you really doing as much as you could do in order to sort of protect them from either leaving or being discovered. And then here's a few resources of really good information that's credible information that you may be able to use. There are also free resources, some IP training. The Canadian Intellectual Property Office, CIPO, has a real good section on education and other resources that are available. They include videos. There's even, I think, some template documents and different things like how to put together invention disclosures. They also have a YouTube channel with other videos as well. And then Gowling, our partner here in our presentation, also has some articles and different resources that are available on their website as well, and also obviously very credible source of information for you to use. So now I'd like to just pass this back to Sean. Our MC is going to take us into our question period.
Great, thanks, Rhonda. Just to confirm, you can hear me okay. I always want to make sure that. Great. So again, it was Peter Milne with Gowling and Rhonda O'Keefe, our senior IP manager at NGen. Some great insights. So just before we jump into Q&A, I have been tracking, and luckily you've put them in both chat and Q&A. So keeping me on my toes, which is great. So just before we jump in, I want to mention there is going to be one more polling question at the end of the Q&A, and that is really going to help us design the next session, if you will, for you. So please stick around for that question. We'll try and do our best to get this wrapped up top of the hour, but if we get too deep into it, we may go a few minutes past. But try and stick around for that question so we can make sure we design these to meet your needs. So to jump in, what I'm going to do, I'm going to kind of start with Michael Lalonde posted the first question, and I'll just read these. So here's what Michael said. What I've learned through a recent patent process is that no matter how clear a patent may be, it does not prevent anyone from challenging it. And the onus is on you to prove an infringement, or if it's challenged, prove it is valid. How can a SME protect itself from large multinationals that have reputations of predatory practices and litigation?
All right, Peter,
Well,
start off.
that's a question that gets asked a lot. I had a U.S. colleague once that said that patent litigation is the sport of kings. That is a problem. I mean, you need to be careful and make sure you're not treading on anybody's intellectual property. What is the reality? You know, can you realistically, sue a major multinational for patent infringement? Patent infringement actions go on for years, and the cost to do it is in seven figures, maybe higher. So that's it's a good question, and that's really one of the challenges to the patent system. There are entities now, and this didn't exist in the past, who will actually take on a patent litigation suit on a contingency basis. So that might be one option if you don't have deep enough pockets to finance your own enforcement activities.
I mean, one thing that I would say too, I mean, if you are going to take the time to file a patent and you do think it has value, I'd really spend some good time doing a really good prior art search before you even head down that path. Especially if you're conscious about, you're not the kind of organization that's going to pepper everything with patents, and you can't afford to file, a huge portfolio of patents. And the ones you do have are really important to you, and your technology is really important. Is take this step and maybe spend a bit of time doing a prior art search so you know how valid or how good your patent might be before you even file it. So you don't waste money on patents that really aren't going to go anywhere.
And the prior art search might also locate art that you need to be worried about with respect to inadvertently infringing. You weren't aware of it. Prior art search is not really a substitute for freedom to operate, because freedom to operate is going to go a lot broader. The prior art search is going to be focusing on closely related technology and not sort of other aspects that are related.
Yeah, more for validity. More for validity of your patent and the patentability. But yes, definitely freedom to operate to stop yourself from infringing, of course. Yeah.
Okay, so the next question, Rhonda, we might have lost that last screen you had up there, if you want to put that back up. So this is Jillian, I believe. If you have a company name, can you copyright or patent that, especially if your product is known as that and the competitors use it, for example, Coca-Cola, Pepsi, etc.?
Okay, the way to protect your product name is through the trademark regime. The one thing you want to be careful of is a business name registration is not a trademark registration. These are two separate regimes, and they exist for different purposes. Now, if you use your business's name on your product and you've developed goodwill and reputation, then you would have what we would refer to as an unregistered trademark, or the more technically correct would be common law trademark. Copyright might enter into it, like if you have an interesting design or logo, that's an artistic work, and so you can protect that sort of through the copyright regime. There is overlap here. There's there are things where you could actually have patents, copyrights, trademarks, and industrial design on the same article. And the example I'll give, and I keep coming back to this one, is your Coke bottle. Your shape is an industrial design. Originally, it's probably as distinguishing guys now. You've got Coca-Cola in the script. And there's probably patentable technology with respect to making the bottle and filling the bottle.
Great. All right. And next question we have is from Anne. She said, our small business collaborators do not actively manage their IP, pointing to the problem of getting a reasonable return on commercialization. They're more likely to give up IP in return for a partnership or a vendor relationship with a large firm that can develop or open markets for the technology more quickly as part of the supply chain in order to use the returns to grow their business. What advice do you have for companies in such a position?
Well, the question kind of answers itself. If you have technology and you think somebody might be interested in it, you got to go hunting around for whoever might be interested in it. And then you enter into the discussions as to, what is the interest? How are you going to share the technology?
Yeah, I think the thing is to also consider. I mean, it's a difficult, I think, decision for any organization when it comes to companies wanting to own your intellectual property or have exclusive rights to your technology. I mean, it may help you grow, but at the same time, it could maybe potentially hurt you in terms of other opportunities down the road with, sort of exploiting your technology outside of that one customer. So, I mean, if that's a difficult decision. And I've heard, people in the music industry talk about, owning their own songs and how that's, helped or hurt them in the long road. I just watched actually a documentary on Dolly Parton where she actually kept her big song that Whitney Houston eventually did. She refused to give it to Elvis. And that was probably one of the biggest business decisions or best business decisions she said she ever made, was keeping ownership of that song. So I think it's a tough decision for any company to make.
It's funny, Rhonda, I just watched that exact thing on Netflix
Yep.
the other night. Okay, then the next one, and sorry, I don't have your name, it's just an email address. In considering collaboration with academic institutions, do you have any recommendations as to how to construct the IP term sheet such that there's no impediment to commercialization of technologies resulting from the collaboration itself?
I might put that one over to Rhonda.
Yeah, I mean, I've been in a situation. I've worked for an organization that has done some academic work, and what we did was we sort of parsed it out. We sort of looked at, in our markets, in our areas, that the organization would own the IP as it related to the sort of application side of things in terms of, we own the IP in this particular market area, but that the academic institution sort of owned it more at like the fundamental level, that wasn't going to hamper the commercialization activities of the company, and they could then work with other organizations that weren't competitive to the manufacturing company and maybe develop solutions for other non-competitive uses using that same IP, but for areas that weren't going to cannibalize the business of the company doing the work with the academic institution. We sort of went down that path.
All right. Next question is from Andrew. Is there a risk to securing IP as a trade secret and having a competitor patenting the same IP?
Yes.
Definitely. That's the risk. And I've seen it before. I've seen same solutions coming up at the same time. When we've done prior art searches, and lo and behold, our competitive company has within 30 days of us come up with the exact same solution. Luckily, we were first, but then I've also been on the losing end of that as well. So, I mean, trade secrets, the same could hold true for that as well. They could be working on the exact same problem solution. So there's risk. Peter?
Okay. All right. Next one's from, I think it's Kara, excuse me if I mispronounced that. How is this affordable for pre-revenue startups? And I assume she means the whole licensing of IP.
Oh, the registration of IP. maybe Peter, you could talk a little bit about, there are strategies to try and keep your costs down a
You can stall. Ultimately,
bit.
getting patent protection is relatively expensive. And if you're looking at a global portfolio, yeah, you're, hundreds of thousands of dollars. What you can do is, work on it incrementally. So your first thing that you do is you file a provisional application, and that buys you your first year, and you haven't spent a lot of money at that stage. And then you need to make a decision: are you going to go ahead or not? And so, you're a year down the road, and hopefully, you've got some revenue, or at least you're generating interest that people might want to invest in your particular startup. And then, if you make a decision that, are you going to file in just North America, in which case that might be the step at which you file Canadian and US patent applications. Excuse me. If you still want to keep your foot in the door longer, then you file a application under the Patent Cooperation Treaty. The Patent Cooperation Treaty is basically it's it's a foot in the door for another 18 or so months. Well, yeah, it's 12,
Like a placeholder.
It's a placeholder. It's like you're buying an option to maybe file patent applications in the future. And so with the PCT process, you can stretch this whole thing out to 30, 31 months. But by then you have to, really be in a position and have some finances in order to go after protection in different jurisdictions.
Great. All right. So Ben has posted I think a comment and a question I'll read. Something we've noticed in our experience with filing and winning our patent is that law firms who specialize in patent law tend to move slowly and incrementally, making small changes and taking feedback from the patent office until we get it just right. This iterative process is very costly for a startup. This is a common workflow, but really is better suited for big corporations that can afford the legal costs. In our case, for instance, in the end, we ended up making all the changes we wanted to make at once because we were burning through our budget against the recommendations of our lawyers, but we knew it would work and it did. How do we avoid this long process in the future? Is it just a matter of putting our foot down, so to speak?
I think every patent agent is going to try and get the broadest possible protection they can. And I think that's probably why they're often reluctant to give up more than they need to in an office action, because it might not serve you so well. However, if you look at the recommendations and you work with them and understand what you're trying to achieve with your patent, you really consider the limitations that you have as options. And if some of them, in your mind aren't that restrictive, you could have that conversation like you did with your patent agent. But I think, I don't know, correct me if I'm wrong, Peter, but that would be the reason they're really taking those incremental steps towards, they don't want to give up more than they have to.
Well, I guess as dealing in any relationship, communication is important. Your patent professional has to sort of be in tune with what you're hoping to accomplish with the patent process. The patent process is slow, and it's not the patent agent that makes it slow. For the most part, it's the patent office. You file an application for a patent in Canada. You may or may not request examination at the time of filing, but you request examination, and then it's maybe 2 months before you receive any correspondence from the patent office. And then, you review it, you make recommendations, and basically, send your comments and recommendations to your client. Some clients will give you instructions in 2 weeks. Some of them you're chasing them 6 months down the road. So sometimes the delay is at that end. And, once we receive instructions, we tend to file a response relatively quickly, but then that could wait another 6 or 8 months in the patent office before a patent examiner takes a look at it again. And, every one of these steps takes time, and there's an expense associated with it. And I don't really, there are ways of speeding things up. Let's say, for example, you're successful and you file a PCT and you have a favorable what they call the International Preliminary Examination Report, or you have success in a jurisdiction that moves a little faster. And I would say, US is probably a bit faster than Canada, as long as the case goes easily through the system. And that there's a mechanism now called the patent prosecution highway. You can take your favorable results in another jurisdiction and apply to different patent offices in Canada, the Canadian Intellectual Property Office, and and you amend so you Canadian case now looks like the one that you were successful in, and you request that expedited prosecution. PPH case, you could probably get through the system in 4 to 6 months.
Yeah, that can work pretty quickly. I also think that sort of going back to the prior art searching and really understanding a little bit what your patentability is helps you understand where to go a little quicker too, and maybe could prevent some of this if you really have a really good understanding of what's new in your invention, and you're not sort of, it's not like a shot in the dark. So that understanding of the prior art and feeling like you've done a really good search and you know what you're asking for and you know what you deserve with the patent office helps up front too.
Okay, and then the last question, and I'm gonna paraphrase it a little bit. There's a few questions in one here. So the question is from David, and specifically he's referencing the differences between Canada and the U.S. But his question is, can knockoff imports, and I think he means out of North America, be blocked by CBSA or blocked in other ways? And kind of tied to that same question, can a manufacturer go after the buyer or local seller of the counterfeit or infringing goods?
Well, the U.S. does have, I think CBSA, is that Customs Border
ITC?
Security Agency or something like that?
CBSA is the Canadian version.
Yeah, it's ITC, I think, isn't it? Or is that?
Yes,
oh, no, that's,
I mean,
yes.
there are mechanisms to do that.
Mhm.
I'm not on the enforcement side, but yes, certainly I know they can be quite powerful, particularly in the U.S. to register your design or your trademark with them, and they will actually form their own opinion. And if they think there's an issue, you get notified and the goods get blocked. And Canada's, I don't know if they have yet or is in the process of introducing similar procedures as part of the sort of amendment to our intellectual property laws a couple of years ago, or just last year at this time, actually, October 30th of last year, to be more compliant with treaty obligations in other jurisdictions. And that was one of the things that was part of that, part of those revisions. Going to China, tracking and prosecuting, that would be challenging because China's not exactly famous for, honoring intellectual property rights. They're getting better. I mean,
Yeah,
20 years ago, I would have said, no way. I think, now, we have an office in China, and, I'm sure they could help, if there's a situation like that. But that's not often the way that it's done. I mean, you don't typically apply for a Chinese patent to stop Chinese knockoffs. And the thing is, if you don't have formal intellectual property rights in China, you're not going to stop anything, right? You have to have that patent or trademark or whatever. And, given the enforcement challenges, it's a question of, do you want to get that Chinese patent? But when you have a patent in other countries, say Canada or the US, that stops people from making, using, and selling. Those are the three rights that you get with your patent. And included with that is importation. Just because it was made in China doesn't mean you can use and sell it in Canada.
Great. Thank you very much, Peter. So once again, I want to thank Peter Milne and Rhonda O'Keefe for joining us here today. As promised, we're going to put up on your screen the final polling question. Your responses to this are greatly appreciated and going to help us frame or set up our future events for you. And as you're doing that, I just want to mention briefly as well that, as alluded to earlier, we have another event coming up this Thursday in our What's Next Thought Leadership series at 11 a.m. Eastern Standard Time. Please watch your newsletter on Wednesday from NGen if you'd like to sign up for that. Also, as I mentioned in the chat earlier, we're going to send out a copy of the slides and a link to the recording to everybody who attended here today. So you'll be able to reference back to that. And if you'd like to see future events, make sure you watch that event tab on our website for updates. All right, Frank, what do we have here for responses from our final polling question of today? I feel like there should be a drum roll here. And as I mentioned earlier, just if you keep an eye on your upcoming newsletter, you're going to see future events you can attend. Okay, here is the polling results. What topics are of most interest to you for future Access the Experts intellectual property webinars? So we got about 26%, how to put together an IP strategy. I got a few responses. Collaboration agreement is had 16%. I'm just going to hit the highlights, obviously. How to work with a patent agent attorney, tips for dealing with outside counsel was 21%. And then we had several here down at around 10 or 11%. So we're going to take the results of this survey and use this to design our next Access the Experts intellectual property webinar series. And with that, again, I want to thank you, Peter Milne, for joining us today, as well as Rhonda O'Keefe for joining us. It's been great having you here. Hope you, our attendees, have gotten some value from today. As always, feel free to reach out to us here at NGen if you have any questions or comments on how we can continue to make these events as valuable for you as possible. And I'm just going to ask Rhonda, anything to add, or are we good to sign off for the day? Great. All right. Well, thanks again, Peter. And thanks again, Rhonda. Thanks again for everybody for joining us. Have a great rest of your day.